Welcome to everyone who is joining us here today for the Will Work for Food Hour, part of the new for the Will Work for Food project, part of the new Possibilities Hour. As many of you know, we see you on a weekly basis, many familiar faces. This is a weekly seminar series for mediators, lawyers, arbitrators, and anyone who negotiates. The Will Work for Food project was founded by Natalie Armstrong Matan in 2020 as a way to build community among colleagues who were separated during the pandemic, and also a way for us to raise money for food banks around the world. And 6 years into the program, we are still going strong thanks to your support and attendance. Each week, we bring you an amazing speaker, and rather than charge a fee, we ask you to consider making a donation to a local food bank, either the one that's sponsored by our amazing speaker today or another one of your choice. One of our favorite parts of the program every week is to announce the running total of donations we have been told about by our generous audience. So for that, I will pass it over to Natalie Armstrong Matan to do the honors today, please.
Hey, thanks so much, David. Hello, everybody. So we have some lovely folks who made donations to food banks who had corporate matching, which doubles your donation. And today the number is $927,144.90. Thank you all so much. Also, if you're unable to make a donation in monetary form, we encourage you to volunteer at your local food bank. And in 2026, we're going to start keeping track of all of the hours that folks donate to their food bank because that is just as valuable. And we greatly appreciate that service that you do.
Fantastic, Natalie. Well, thank you so much for that. And thank you again to our generous audiences for your support. And now for this week's program and our fantastic speaker, Annie Thompson. We have a great one for you today, folks. The title of today's program is Handling Emotionally Complex and Structurally Challenging Mediations and Legal Malpractice Cases. Annie Thompson is the Chief Claims Officer for Lawyers Mutual Insurance Company. Annie leads the claims department overseeing litigation and pre-litigation strategy and legal analysis of duty, breach, causation, and damages in the defense of claims. She's also responsible for the evaluation of coverage concerns regarding policyholder tenders. She participates in mediation and settlement negotiations on behalf of policyholders, and she also provides hotline assistance with ethical issues or concerns from policyholders. Annie has had a tremendous career working in the insurance industry and administering claims. She's one of a handful of certified specialists in the state of California that has expertise in this practice area. I've heard her speak before. She's an active participant in educational programs we have through the Beverly Hills Bar Association, and we're really fortunate to have her here today. And Annie's charity is Food Share of Ventura County. So with that, Annie, I'd ask maybe you could tell us a little bit about the food bank you've designated, and then the floor is yours.
Okay, thank you very much, and thank you for the kind introduction. I was looking around, I didn't have a food bank that I was necessarily affiliated with, so I looked for my local food bank and looked into a little bit of what they do, the accolades they've received, and I found it to be a shocking number that 1 in 4 in Ventura County were food insecure. Um, I think there's an impression in Ventura County that, everybody's sort of beachside and doing just fine, and the reality is they're not. So that's why I chose Food Share of Ventura County, which is my friends, neighbors, colleagues, and my kids' friends as well. So that's why I chose that. I felt like I would try to make a difference in the local community. And so obviously I encourage you all to donate, and I would be very much appreciated. So today I'm going to talk about, as David said, emotionally complex and structurally challenging mediations in the area of legal malpractice, defense, and pursuit. So before I started as a chief claims officer at Lawyers Mutual, I was a litigator for a decade also, and then sort of switched hats and came to the insurance side, where I see myself more as sort of a neutral evaluator than a defense lawyer. But because really, I mean, it's my job to call balls and strikes, not to necessarily advocate. We have defense counsel involved. They will advocate for their clients, and I will take into consideration anything that anyone has to say to help me get it right, and not win. I don't think in the insurance industry, where you have a duty to your insured, there should be anything about winning on behalf of the insurance company, which I think sets Lawyers Mutual a little bit apart, but we don't do that. I want to just get it right. So that's a little bit about me and what I do. I would love this today to be interactive. You're free to put questions in the chat. You're free to interrupt me and ask a question or wait to the end. I'll continue to ask if you have questions throughout the program. I think this is a very interesting area, and probably not a lot of you on here have litigated legal malpractice cases, but they're really very interesting. So we're going to explore over the next bit why these cases are different, how the parties approach them, and what mediators can do to guide them towards productive resolution. In here, I have a couple of questions also to sort of throw out if you all are willing. So let's set the stage a little bit. When a legal malpractice claim arises, it typically means the client believes that their lawyer failed to meet the professional standard of care and that the failure caused harm. Sometimes it's a missed deadline. Sometimes it's a strategic decision the client now believes was wrong. Sometimes it's a conflict of interest. Sometimes a lack of communication, making the client feel stranded or abandoned in some way. But what sets these cases apart is the case within a case. The plaintiff has to show that not only did the lawyer do something wrong, but that they would have won or achieved a better outcome if the lawyer had acted differently. So the mediation then becomes a relitigation of the original dispute and an evaluation of the malpractice claim itself. The very typical answer is if a lawyer blows the statute on an auto v. auto case and you are the plaintiff, well, so okay, we have duty and breach, easy. Lawyer was retained, had a duty to file suit, and failed to do so. That's very easy. Causation and damages ends up going to this whole dispute, and there's a plaintiff who says, my lawyer wronged me. Yes, your lawyer wronged you. Causation and damages, who's at fault for the dispute? What were the damages? Did you have previous injuries, underlying conditions? What does the police report say? What do your medical records say? What does the underlying defendant have to say? And then, even more so, is collectability. So let's say you've got these terrible injuries, but in the underlying case, the other driver had a 1530 policy, which is in California, the required minimums. Or even worse, let's say they had no insurance, they don't own a home, they don't have any assets, and if you went to trial, you would get a piece of paper that you'd never be able to collect on. So the reality is, in that legal malpractice case where you have such a clear error and the lawyer definitely made a mistake that is undeniable, to tell a plaintiff then who was injured in a car accident, who hired a lawyer to assist them, that they have no case despite their injuries and despite the mistake, because had it gone as planned, you would have ended up with nothing. Trying to explain that to an unsophisticated litigant, and sometimes even to their lawyers, because I will say, as David said, I'm one of a handful of certified specialists in legal malpractice law in the state of California. There's fewer than 100 of us. Most of them are defense lawyers. There's a handful of plaintiffs' lawyers. So there isn't a huge, network of plaintiff lawyers in the legal malpractice field like there are in the plaintiff personal injury field. So sometimes the folks who take on a plaintiff legal malpractice case don't understand the case within a case either, and don't necessarily have a clue of what they're doing. They see the same thing that their client does. So there's a lot of education in this. I prefer to have somebody sophisticated on the other side, so that, because they're easier to deal with, they understand these issues. David, you had a question?
Yeah, I was just going to say it must be such a difficult conversation to have with a plaintiff, because on some level, how do you deal with this inherent conflict or inconsistency where they're like, well, my lawyer told me I had a case. I imagine you hear that all the time. We were supposed to have a recovery here. Otherwise, why would he have taken my case?
That's exactly right. And when the lawyer realizes that they have made a mistake, they have to write, pursuant to their rules, their duties under the rules of professional conduct, you need to make this disclosure. And I always recommend make the disclosure in person and then again in writing, saying, you may have a claim against me. You hired me to do this. I failed to do this. Please consult other counsel. Time is of the essence. So then you've got that on top of it. Well, he told me he messed up. And so it does become really challenging to try to tell a plaintiff who has been told left, right, and center that they have been wronged. And again, same issue, David, with, well, why did you take my case? Well, because there wasn't discovery yet, and we didn't actually know what the underlying limits were, or that this particular defendant had no assets. So, I mean, that's the answer to that, but it's a tough pill to swallow for a plaintiff. And sometimes it's tough for plaintiff's counsel who may not necessarily be familiar with the nuance of legal malpractice law, which is what makes it so different and why I've been doing it for 25 plus years is, the case within a case can be anything. It can be personal injury, it can be estate planning, it can be maritime law, it can be, underlying insurance bad faith, business deals. I mean, workers' comp, employment, it's everything. And so, in doing this for so long, I really have sort of cocktail party knowledge of every practice area. And, we see some repeats in like family law and estate planning where I've learned a lot about practice areas I never had any interest in, but family law we'll get to because that's really emotional. And we'll talk about that. But so the plaintiff, as we were saying, this loss feels intensely personal. They trusted their lawyer with something important, sometimes their freedom, their money, their family, their business. When things go wrong, they don't feel just disappointed. They feel betrayed. They feel abandoned. They feel unheard and disempowered. I hear that plaintiffs say, my lawyer didn't listen to me. My lawyer didn't fight for me. My lawyer didn't communicate with me. They left me in the dark. And a lot of times, and this is just basic humanity, maybe they want money, and often they do, but they also want acknowledgement. They want an explanation. They want someone to recognize the impact that this experience had on them. So going into a mediation or a legal malpractice case requires a level of patience with a generally unsophisticated plaintiff who wants to understand why they're here now and not where they thought they would be, why there's been so much time. They don't understand how long litigation lasts. And this just becomes, a very tall ask for a mediator to explain to the plaintiff what is going on. And I think in legal malpractice mediations, it is very important not to start horse trading early on. It's very difficult to have a half-day legal malpractice mediation, although it's possible, if you've got, motivated parties. But it's really about starting with the plaintiff and their emotions and letting them tell their story that they never got to tell. And that's a really big deal, which is why most of our cases settle in mediation, because I always say the plaintiff needs a process. Sometimes the defendants need a process too, so I'll talk about that. So let's shift to the defendant, lawyer. For lawyers, their identity is tied to competence, credibility, reputation. When they're accused of malpractice, they often feel shame, fear, anger, and a deep sense of personal threat. They worry about their standing in the legal community. They may worry about disciplinary consequences, and they may fear losing clients, losing income, or being reported to the state bar. I would tell you most of the time, these are all fear-based fears, of course, but they're not necessarily realistic as to what goes on. So a lot of the job that I have when I talk to these folks who've just been sued, there's a lot of therapy in that for the defendant as well. Because you say, this is why you have insurance. If this is the worst thing that happens to you in your career, that's a good thing. And talking to them about why this isn't reputational, why every lawyer can expect a claim every 7 years, why this is just part of doing business. And especially if it's a case that's easily defensible, you say, look, this is really not a big deal. I'm not worried about this. You shouldn't either. And you please get some sleep tonight. I've got lawyer defendants who don't tell their families, their spouses, who just want this to go away. and they're afraid, am I going to lose my house? And this happens especially when the defendant lawyer is not a litigator. If a defendant lawyer is not a litigator, but an estate planner, let's say, and that's where I find a lot of this. An estate planner went into estate planning because they really didn't want to be in a courtroom. And they have the most frequency and severity, meaning they have claims more often and they're more likely to be severe because at least in California, anyone who owns a piece of property is a millionaire. And so when we insure, solo small firms, and our limits are, go anywhere from 100,000 to $5 million. And sometimes they say, well, I've got $1 million policy, but I'm underinsured, so I want you to pay this. And the carrier will say, well, look, based on advice of defense counsel as well as our evaluation of this case, it's not worth $1 million. And in fact, I don't think you did anything wrong. So that becomes an issue also. So we'll talk about that in a bit when we talk about the insurance part of this. But the plaintiff comes into a mediation wanting validation and empowerment, and the lawyer wants vindication and protection. That is an emotional mismatch, always. And that's at the heart of most impasses in legal malpractice mediation. So understanding that mismatch is the first step towards effectively mediating this case. And then now we'll turn to the other driver of mediations, which is insurance. In most cases, the lawyer has professional liability insurance. In the state of California, if you don't have liability insurance, you have to disclose that fact to your clients, which is a very uncomfortable conversation to have. By the way, if I mess up, I have no insurance, and that has to be disclosed. I see that most frequently in criminal cases, where a lawyer just says, I don't need insurance, and they don't get policies. But be that as it may, obviously the ones that I'm involved in, the lawyer has professional liability insurance, and that means the carrier is quietly controlling parts of the process. We select defense counsel, we control settlement authority, and we make evaluations based on risk exposure and a little bit of cost of defense, although I'm going to tell you right now that as a participant to mediations, I really don't like when a mediator tells me, well, cost of defense. Well, the cost of defense has gone up exponentially. And if you're telling me I should spend $100,000 to $200,000 on every case because I'm going to spend that defending it, that doesn't sit well with me because I pay for conduct, not for, sometimes obviously I'll make those business decisions, and usually we'll make those business decisions in the context of a mixed liability case where, I think that we're going to win and it's just, or we're going to lose, but it's a question of how much, and we're disagreeing. Maybe that has a premium. I don't know, but cost of defense doesn't work well on me. It may work with other carriers, but I like to talk about the merits of the case because that's how we try to get it right. But there could be coverage issues beneath the surface. There might be a reservation of rights, and counsel may be independent, or counsel may, pursuant to their right to have counsel of their choosing when there are coverage issues at stake that can be controlled by defense counsel. And one of the things that we see a lot is the insured may have a fee claim that they don't want to give up. So our consent to settle provisions come into play, a hammer clause comes into play, and there may be disagreements between the lawyer and the insurer about whether settlement is appropriate. The case of the, estate planner who is, talking to the insurer saying, I've got $1 million policy and I really want this case settled because I'm scared of excess exposure. Well, the carrier is saying, well, the maximum exposure is 1.3, which is not a, break the company analysis. And the evaluation is that this case is worth $200,000. Well, that becomes a little bit of a rub between the insurer and the insured, but it doesn't give rise to independent counsel, although they're always free to have independent counsel. Go ahead, David.
Yeah, I was just going to ask if you could expand on the consent to settle provisions and the hammer provisions you mentioned, and maybe what some of the nuances are of those from your perspective.
Sure. And those are the ones that get really interesting, because we can have a case like I was just mentioning where the consent to settle, I'll view it as unreasonable because it's based on fear of an excess judgment. We have other ones where the defendant lawyer is so entrenched in their position that they say, I won't pay a dime. And so that's where the hammer clause can come in. We'd say we have a demand to settle for $10,000, and it would get rid of the case, and if the case is worth at least that much, and this is great. And sometimes defendant lawyers think that if they stay strong and bully their way, they will, they're playing a game of chicken and the other side will jump. Sometimes they're right. And so in a case like that, if they don't consent to settle when there has been a reasonable demand recommended by defense counsel and the insurer can write a letter stating that it is our position, pursuant to our policy, that if you fail to accept this $10,000 offer, the company will have no liability beyond that number should this case result in a number greater than that. So if you don't consent to $10,000 and you get a verdict for $100,000, then we take the position that there's $10,000 that we agreed to pay. The other 90 is on you. And that can be very powerful. And I'll tell you, in 15, 16 years at Lawyers Mutual, we have used the hammer clause to encourage an insured to revisit and their position. And quite often they do, because they don't really understand the impact of that. And so consent is a very big driver in legal malpractice cases. And it's very much can dictate the whole mediation, because the defendant doesn't want to be there. They don't want to pay anything. And so sometimes a mediator can be really instrumental, because mediators are usually lawyers or judges talking to another lawyer saying, well, what if the jury, this is like sort of one of my favorites that I use when I mediate, is what if the jury doesn't see it that way? Is there any possibility that you can fathom that a jury might not agree with you? And usually the ones that are really, bullish on this are the ones that are litigators who think they can win everything. And so it's not usually an estate planner or even, a family law lawyer. It's usually someone who's involved in civil tort litigation who just who understands risk and says, I'm fine. Or I don't want to pay that because I've got a $300,000 fee bill and I'm not giving that up. In that case, you can't hammer them. So then it becomes very interesting. I have a case that went to trial, and there was a demand for $150,000, but it had to subsume all matters of litigation, including the fee claim. The insured wouldn't consent. 150 was more than I thought the case was worth, but it definitely was worth it to get rid of it at that point in time. And the jury came back and awarded right around $150,000 for a return of fees, as well as 70-something thousand dollars on the legal malpractice complaint. So that's a case that we would have liked to have had the ability to hammer, but we didn't. And we ended up incurring lots more in fees to get there. So I have a question in the chat. It says, are defense costs not something you want us to bring up because you consider them a normal and necessary expense of claims processing, which is used as a parameter for setting requests for increased premiums anyway, and will be incurred and covered one way or another? Not exactly. And that's a good question. So I like to talk about conduct. I don't want to talk about, costs of defense are interesting. They're not really used as a parameter for setting increased premiums and will be covered one way or another. So the other thing about legal malpractice policies is they are burning limits policies, meaning every dollar spent on defense takes away from indemnity, which is also very challenging in a mediation, because every minute you're at mediation, there's an expense allowance on our policy, but not all policies have it. They can burn from $1. But these policies are, they're consistently decreasing. You have $1 million policy, and, every dollar spent on defense reduces the amount of available indemnity, which we do have to consider. So the reason I don't like defense costs is because it seems like a very unsophisticated argument to me that I should pay because it will cost me X. You're not telling me I should pay because the conduct warrants a payment in that amount. You're telling me I should pay because it'll cost me more to defense it. And that's not something that is really appealing to me because, again, I pay for conduct. I don't pay for peace of mind. I don't pay, and we're out here every day earning a reputation. And if I become known as somebody who will pay cost of defense every time, then it's not a good look considering, we insure more lawyers in California than any other carrier. And it's not a great look to have a reputation that you will roll over, that you won't try a case where you think there's no liability, and that you will always pay cost of defense because you don't want to litigate. And so it's a combination of both of those things. It's a combination of this is not a merits discussion, and it's also that I can't earn that reputation in the community. So those issues really arise a lot in mediation. The consent provision is really a big deal, and on both sides, a withholding of consent and an unreasonable use of consent. That can factor in, and mediators have to know enough about these policies and these provisions to be able to handle these things. Because sometimes, the carrier or defense counsel can't necessarily impress upon a particular lawyer the risks if the case should be settled. And sometimes a mediator can really talk about this from their own experience, either in handling these cases or judges in overseeing these cases. And quite often, actually, judges, if I've got a very, difficult insured, they may need to hear from a judge about what is likely to occur if they continue to withhold consent. And so that's kind of, that's like the triangle: the plaintiff, the defendant, the insurer, each with different incentives, concerns, and emotional stakes. But coverage issues are critically important. They affect negotiation, decision-making, emotional tone. If a mediator ignores the insurer's role, they're going to have a hard time effectively mediating. There's a lot of lawyers worry about privilege and ethical concerns in a legal malpractice case, but is sacrosanct as the attorney-client privilege is, it is essentially waived in a suit for professional negligence. A lawyer is allowed to disclose certain things in order to defend themselves. And mediators really have to encourage clarity and caution around confidentiality, just to make a defendant lawyer feel comfortable and not give ethical advice, but to help parties speak safely with agreed upon boundaries. So there, the duty of loyalty and confidentiality, obviously, well, not obviously, but it does continue past the representation. But if your legal services in a particular matter are questioned, that is waived by the plaintiff by virtue of filing suit, and you can talk about what you need to talk about in order to defend yourselves. A lot of lawyers feel very uncomfortable even when they first call in. Well, what can I tell you? So you can tell me what you need to tell me. And so sometimes getting over that hurdle with a litigant is difficult and needs some massaging. And so the mediator has to use their tools to help the case move towards resolution. So I was talking earlier, first, the plaintiff's need for acknowledgement. So a plaintiff wants to understand what happened. They want transparency. They want validation that their distress is real. They may want an apology, which doesn't really go over that well in legal malpractice cases. Apologies are, for whatever reason, lawyers have a very difficult time making an apology, even if they're sorry. They feel like it's some sort of admission of guilt, and they don't want to do that, even though we're not talking guilt and innocence. lawyers have a very difficult time with apologies. So we usually take those off the table. But what a plaintiff wants is recognition of their experience, is what I have found in mediating and in being a part of the mediation, is a plaintiff wants their experience recognized and understood. So that's a big part, which is why I said no horse trading for a plaintiff at the beginning of a legal malpractice mediation, because that is where they are going to tell their story. That's where they're going to get to say what they wanted to say if the matter had been handled in the way that they had expected. There's also managing expectations of a plaintiff can also be very difficult. We talked about this a little bit at the beginning, but the case within a case is very difficult to understand. And there's so many nuanced defenses in a legal malpractice case. Like one of them is called settle and sue. And so if you were being represented by a lawyer in an underlying tort action, and you decided to settle the case, and then you turn around then and sue the lawyer saying, I would have gotten a better result. I would have been able to settle for X, Y, and Z. I would have received more, or I would have paid less, depending on what role the legal malpractice plaintiff had in the underlying case. And we've got a lot of defenses on settle and sue. Is basically an area of defense that is well documented in the Court of Appeals cases. So that's a very strong defense. And so you really sort of get closed at the front door by virtue of, settling a case before and then saying, well, it wasn't enough, because the analysis is this in the ballpark? Was this reasonable for the circumstances? And they don't necessarily understand that by settling a case that they've foreclosed on their rights, essentially, because the case law is so strong in support of lawyers that getting that second bite at the apple in I didn't settle for enough or I paid too much is really sort of Monday morning quarterbacking. And looking back on it, the judges give a lot of discretion to whether or not this was in the ballpark and whether or not you have adequately explained that to the particular client. And so that takes some nuance by the mediator to explain this, because what's happening is the defense counsel is presenting this to plaintiff's counsel. Plaintiff's counsel may or may not understand it, but they're also saying, well, that can't be right. That can't be right. If they didn't do an expert deposition, or they put up the wrong evidence at trial, which forced us to settle, how can it be that I can't then sue them for their negligence? It's a very difficult thing to understand, but it's how the case law shakes out. It's about not second guessing lawyers and their decisions and litigants and decisions they've made and agreements they've signed. If we were to second guess everything, then we are continuing to relitigate, and that's against public policy, and you're bound by the decisions you make and the agreements you sign. So that sometimes takes a strong mediator to be able to relay that information to help them understand things that are not intuitive at all. I have another question here. What about when the relationship between the lawyer and the client has been difficult, where they may have argued over bills where it's been a tough road for them? Do I find that it drives a lot of claims, and how do you manage it in mediation? Yes, fee disputes can drive a lot of claims. And so if someone calls in, on a hotline call and says, my client owes me $100,000, I'm not willing to walk away from this, but I don't know what to do. And so the advice that we always give, or the best practices that we give on a hotline, is the statute of limitations under Civil Code 340.6 is 1 year after you have ceased representation. The statute of limitations for breach of contract is 4 years. So wait until the statute has run before you give notice of fee arb or file for your fees. But I often encourage, regardless of the amount, because these things always turn into a headache, whether it's $10,000, $100,000 or more, it's almost never worth it to seek your fees. A lot of times they're not collectible, they're not paying because they don't have the funds. And even if you sue after the statute of limitations is run for your malpractice, it can still be used as an offset. So they can counterclaim for legal malpractice and it's time barred, but they can also answer and say the amount they're collecting should be reduced by the value of their services. So you're litigating your malpractice anyway. And so you're hiring standard of care experts, you're hiring billing experts, and you're talking about whether or not you were negligent. So I mean, it's a terrible thing to have to tell folks that, by the way, you're probably going to have to eat those fees. It's terrible, and no lawyer and nobody should ever have to work for free. But that's where my other talks come in about not getting behind on fees. But that's a different story, and lawyers are notoriously terrible business people and quite often fall behind on fees by not keeping the right kind of retainers, by not having recurring payments. And that's how they get into this situation to begin with. So, the best defense is a good offense. So all my sports metaphors today. David, you've got a question?
Well, I was just going to expand on that and say, I can imagine though, a lot of times, a lot of cases involve very difficult and fraught relationships with clients where by the end of it, there's a lot of tension, or you feel like as a lawyer, they've just dragged you through something, or they've been questioning your bills all along the way. And then in a worst case scenario, eventually you get sued, right? And so
Yeah.
does that come up, and how do you deal with that in the context of a mediation and dealing with, the emotionally charged dynamics that you're talking about in your program today when you get into a settlement discussion?
Well, so if you're talking about if they've been emotionally charged by virtue of like tugging at each other in the underlying case.
Yeah.
Okay, so that happens. So where I see that is lawyers and clients. I always talk about this, and this kind of strays a little bit, but you're never more excited about a case than you are when it first comes in as a lawyer. You are communicating round the clock. Everybody's excited. Everybody thinks this is a great case. And then, time goes on, things steady. There's not that much going on. And you have other clients and you can't communicate with that client as frequently as you once did, which is, footnote to that. That's why I always tell lawyers, set realistic expectations. Do not be, texting, calling, emailing, at odd hours at the beginning, because you're setting an expectation. So then when you need to respond and you're not immediately responding, if you need to respond thoughtfully, you need to take some time. Well, that's an aberration from your normal custom and practice as far as they know. And it's a big mistake to make. And so that's where I see that issue arising is clients feel like they want more information. They're getting billed for stuff, but they're not getting reports. They're not getting updates all the time. And this happens more so in plaintiff cases. So they're feeling like they're not looped in. They don't have information, and the lawyer's frustrated because they're like, there's nothing happening. I promise I will tell you. And so that sort of goes in that direction. And what will happen then is everybody's frustrated with each other. They get to a mediation, and let's say the lawyer is just like, I've had enough of this person. And they basically say, if you don't resolve this case today, you're going to have to find a new lawyer. I mean, there's an issue with that because, it's a privileged communication in the context of mediation. So it's inadmissible in a subsequent legal malpractice case, but it happens all the time. And people allege it. And it becomes very difficult in that situation because then they're stuck with so I'm talking about an underlying mediation and then a subsequent legal malpractice case. That's really a difficult thing because they want to talk about the last mediation that was very uncomfortable for them, and then they go to another one. So mediation arising out of a mediation can be very difficult. And this doesn't exactly answer your question, but it's a good example of what happens when there's that rub, and especially when a client will then feel abandoned because the lawyer is frustrated and says, this is a good settlement. If you don't take it, you're going to have to find another lawyer. They feel so pressured and they take the settlement, and then they want to say, okay, but I still have remedies, but they really don't. So that becomes another very difficult situation, and we end up having to deal with all of those really charged situations, because lawyers enter a mediation with a very protective stance. They may deny everything, they may blame the client. See that a lot, but I also believe if you blame the client, you're losing. I understand comparative fault, which is a very common way to say, look, this everybody bears some responsibility for this. Finger pointing at your client is a tough defense, I find, especially if it's actually in most instances. But they cling to the belief that admitting anything will damage them. And in a mediation, it's important for the mediator to be delicate not only with the plaintiff, but with the defendant. Defendant lawyers, everyone always says it must be so difficult to have lawyers for clients. And I never felt like it was, because once they gain trust in you, it becomes a very rewarding relationship. But building trust can be challenging at the outset. And it's the same if you're mediating these cases. They come in defensive, but if a mediator builds trust, the lawyer really becomes a lot more reasonable. And so you have to normalize their feelings. I understand this is personal and uncomfortable. My role as a mediator is to support a process that protects your interests, and I'm not judging your work. I'm not saying you did this wrong, you need to pay up. I'm saying a jury may not see it the way you see it, and there's time, expense, and risk that goes into this. You are a subject matter specialist in something else. You have other clients. You have better things to do with your time than litigate this legal malpractice case and to sit in front of a jury for 15 days and be removed from your practice, or 5 or whatever it is. But I find even my 5-day trials don't go 5 days. So it becomes a very taxing venture for lawyers, which they don't always understand how stressed out they are about this, which is why they come in so defensive, and why they come in so stressed out about it, is they don't realize how much of a burden defending the case is, even if they've got insurance, even if the bills are being paid. An assault on your work product feels really painful for lawyers. And so again, we talk about that, and we say, what do you think a jury would feel about this timeline? What do you think your strongest argument is? Where do you see vulnerability? Where do you see weakness, potential weakness? What's the best outcome at trial? What's the worst? But really the vulnerability is, as a defense lawyer, I think in every case, even a liability case, where you've got, all the elements, you've got duty, breach, causation, and damage, there's always a vulnerable spot, whether it's causation or it's the amount of the damages. There's always a vulnerability on the plaintiff's side, because there's something that's going to prevent them from getting full value. It's just sort of the way that it is. And it's the same on the defense side. Even if they met the standard of care, didn't cause damages, the result wouldn't have been any different. There's always a vulnerability. There may be a letter where you weren't patient with your client that somebody's going to look at and go, wow, you were bullying this client. It may have nothing to do with anything, but perception is reality. And one poor letter in your file that they're going to pick on to say how you were communicating information, that's a vulnerability. So as a mediator, I think what we're looking to do in trying to resolve these cases is look for everybody's vulnerabilities and exploit them gently, because both sides have ego and emotion in it, and really it's critically important to build trust with everyone. I think that's true of every mediation, but I think especially so here, where it's so charged. Michael asked a question, in my experience, are lawyers favorably perceived by juries? This is another one of those things like cost of defense that I really dislike. And that is when a mediator will tell me, well, juries hate lawyers. No, they don't. And we make decisions on which cases go to trial based upon how we think a lawyer will be perceived. If we've got a lawyer defendant who is him or herself a liability because they're, bombastic, or they don't communicate well, or they have a poor memory and they did horribly at deposition and they were terribly impeached, chances are we're not going to trial on that case. So the cases that are selected to go to trial and not settlement are generally favorably perceived defendants. However, I can tell you, I went to trial on a case where I had no ability to settle because of a fee claim. And this jury and everybody and the judge unfavorably perceived this defendant for good reason. The underlying case, this particular defendant had been chastised for unprofessionalism, seemed like he had a personal stake in this litigation, and was really not doing the client any favors. Even in that case, the jury got the number exactly right. They certainly found against him, but they didn't, find anything against him that wasn't legally supportable. So juries are smarter than we think. And all of these sort of nuclear verdicts that people talk about now, those don't come up in a legal malpractice case. You're protected by a number of layers there, because these nuclear verdicts are usually, against insurance companies for bad faith, or mass tort cases, or you've got a business on the side, on the other side. In a legal malpractice case, you're very much limited, and the folks that bring them are very much limited by the policy limits or the damages you can prove, and they're just not, giant cases like that in our arena. Talking about big law, that's different. Because they don't have the same constraints that we do with solo and small firms, and even mid-sized firms. So it's really constrained by that. So in that arena, we don't necessarily take heed of the juries hate lawyers, because they just don't. They really don't. It hasn't been my experience. I've, in 25 years, never had a verdict I wasn't expecting. I mean, knock on wood. Oh, my dog thinks there's someone at the door. I've never had a verdict that I wasn't expecting, and that is that's a gift. But I think it's not just good luck. It is really picking the right cases, knowing your defendant, and knowing your venue. So, but that's an interesting question. So those are the two things that I think when you build rapport with a adjuster, which is another word I don't like in my arena, we're claims professionals. But so you want to talk about more, why the conduct supports this. And you can build a little bit of cost of defense in the sense of how much will it cost you to prove that point. That I can live with. But the whole, cost of defense, and, we talk about inflation, everything's gotten more expensive. A cost of defense isn't a $10,000, $15,000 settlement anymore. You're talking 100, 150 minimum. If you're truly talking about cost of defense, sometimes you can spend that just on experts. So it really just isn't a particularly helpful tool as a mediator to try to impress that upon the claims professional, especially because they're already thinking about it. They know that comes into play, but let them get there would be my best advice to people trying to mediate these cases, is because, there's emotion on every level, and this triangle of insured, plaintiff, and the claims professionals is really, it's dynamic. And so you have to find negotiation structure. You have to move slowly in these cases. You have to lay the emotional groundwork for everyone before you can truly meaningfully start negotiating. And you have to understand, in these cases, the parties start so far apart. And that happens in a lot of cases too, in personal injury cases where they come in above limits and think they say the policy's open, yada, yada, yada. It happens in a lot of cases, but these cases usually start with something close to limits, and comes with a counteroffer of $7,500. And you have to let the parties do that. And everybody can say, I'm offended by this. Well, I'm offended by this. This is not a limits case. Well, it's certainly worth more than 7,500, but you have to let them sort of bracket it themselves and then move to center. So, and everybody understands, we're rewarding behavior based on the next move, not the first move. And so that becomes I think it's somewhat unique to legal malpractice cases where you start so far apart, but I'll tell you, most of the cases settle in mediation. So I think with the defendant lawyer, if you start too high, then that triggers all this, self-judgment and doubt and shame or fear. If you tell the lawyer, I really think you should start at 150, they are like, oh my God. So everybody thinks I did something wrong. And now this is going to settle for this. And what's going to happen? And who do I have to tell? And who do I have to report this to? And it becomes very difficult, which is why defense lawyers, on behalf of their lawyer clients, will often start very low. Same with the plaintiff side, they're going to start high to validate the experience. But that often gets taken care of in the process. Sometimes, bracketing can help. Sometimes a mediator's proposal can help. I know Jeff did a recent some session on the new rules and mediators proposals, but those can be very effective in these cases because each side has a very visceral dislike of any idea that the other side brings. I am not going to meet their demand. I am not going to take just whatever the lawyer gives me. So there's this really visceral, I'm not going to do what the other side wants me to do in these cases. So a mediator's proposal where, a claims professional or the plaintiff will say, this isn't our idea, but, and then they will say, okay, well, I think a mediator can say, well, let me do that in my own way. And then go into the other room and ask them, if that's something they'd be willing to consider, and not necessarily say that it came from the other room. And that is honestly very, very effective to be able to have it be the mediator's idea. This is what I came up with, and this is how I think the case can resolve. And then it doesn't become, I'm agreeing to what they want, or I'm capitulating in any way, because that neither side in legal malpractice cases wants to do that. Even if they've been softened by the emotional groundwork at the beginning, there still is that anxiety that they let me down once before. And are they letting me down again? And am I going to allow that? So that becomes, a big deal. So I have a lot of, case example on my outline, but I don't think we have time for that. So I'm going to sort of close with asking for questions, and if there are none, I'll move on to sort of core takeaways. So if anybody has any questions, feel free to raise hands or put them in the chat. But I don't know how many of you litigate these cases or mediate these cases. They're very fun. They're very challenging. Understanding the emotions and roles that everybody plays in the mediation is critically important to resolution. We have favorite mediators for exactly that reason, because they understand all these dynamics. And so they involve trust, identity, fear, betrayal. It sounds like a movie trailer, but the reality is it does involve all of those aspects of human emotion. I didn't get to talk about it, but a family law case, an underlying family law case, is a whole different species of legal malpractice because you are relitigating a family law case. And sometimes the only reason there is a legal malpractice case is because one of the parties can't let go of the underlying family law case and they need to relitigate it and keep relitigating it. Those are so charged and so can be so difficult to resolve. Ultimately, they do. I haven't tried a case with an underlying family law issue in a decade. Um, and generally they do resolve. But those are incredibly emotional. And so let me go to a couple of questions. Uh, Somebody handled legal malpractice cases as a law secretary, would like to mediate them. I'm happy to talk to anybody after the fact who wants any advice or guidance on that and how to effectively do that. And then the next question is, do I select mediators for their expertise in the case within a case or for legal malpractice principles? That's a really good question because it depends. It depends how complex, like sometimes I will, if it's an underlying employment action, and we need the mediator to understand employment principles and how what the plaintiff is saying never could be legally or effectively done in an employment matter. We'll select a because it's easier in that instance for me to educate a mediator on the case within a case requirement than it is for another mediator to learn all the nuance of employment law. So it's really case specific. If it needs that kind of expertise in the subject matter of the underlying case, then yes, we will find a subject matter specialist. If it's, a legal malpractice case where you need to understand the defenses of, a better outcome, settle and sue, statute of limitations. There's 4 tolling provisions in the statute of limitations, and sometimes people don't necessarily understand them. And so when there's a nuance of the defenses in a legal malpractice case, I want someone who understands legal malpractice. And so it really is case dependent because the subject matter special experts or mediators can be critically important to understanding how that case would turn out. And so that's a great question. And really gives you insight as to how we make these decisions. So I'll close with just saying, successful mediators create emotional safety, understanding insurance realities, managing privilege sensitively, and guiding the parties through a carefully paced mediation and negotiation is really how I think this crowd, should they choose to mediate these cases, I think that is how you gain the most success, gaining the trust of the parties, creating a safe space for everybody to, be vulnerable and for people to have, honest conversations about how things may end up and what the best alternative to to going to trial is. So we try to really push each direction to their breaking point, and usually there's some common ground. So I'm happy to take more questions. I appreciate your engagement today. Am I right on timing?
Yeah, I think Annie, you're right on time. We're at the top of the hour, and so it sounds like if folks want to reach out to you, you mentioned that you're happy to speak with them. So thank you very much for being so
Of
gracious.
course.
Thank you so much for really such a fascinating program today and such a nuanced discussion of the emotional issues that come up in these mediations specific to these types of cases. As I was sitting here, I couldn't help but think to myself, what a fascinating way to practice law and to operate within your career as a legal professional, to work with lawyers when they're sort of, in the most trying circumstances professionally for them. It's truly a service to the community as well. And so thank you very much for your expertise and your hard work on behalf of the profession too. And thanks very much
It
to
is.
everyone for, sorry, just say thanks very much everyone for participating today and attending. It's really been a fantastic program.
Thank you so much. It's been my pleasure, and it is a great practice area. I love representing lawyers. It has its challenges, but I always say I'm the only happy lawyer I know. So there we go.
It's great. Well,
Hopefully that's not true among this crowd.
All right, we've got some great ones on with us today, of course. And again, thanks everyone for your support of Food Share of Ventura County. Please let us know about your donations. And with that, we are concluded. Thanks, Annie. That was fantastic.
Thank you.